Our next topic is trade secrets. A little bit of background. Trade secrets, it provides a means to protect business information. That's the key operative here, business information. It's not private information, it's business information that provides a competitive advantage. Trade secrets, they serve a critical role in furthering innovation and can be commercially valuable to businesses as an asset, any size business. It could be Coca-Cola, but it also can be, a mom and pop shop here in town in Plattsburgh, if they have, a client list that they build off of, and that list could be their secret or their advantage. What might be some examples of some well-known trade secrets? Can you think of any? I'll name a couple. I'll have you post your favorites in one of the assignments, but Kentucky Fried Chicken, their recipe. I think I alluded to a couple in the introduction section. Coca-Cola's cola formula, WD-40's formula for their product. So I'll leave it at that. I'll let you guys surf the internet, try and find, there's lots of them out there, trade secrets. It's estimated that the value of trade secrets held by U.S. publicly traded corporations, just them alone, $5 trillion. $5 trillion. Small businesses also rely on trade secret protection to get their competitive advantage as well. Protecting the trade secrets, why is it a challenge? Why do you think it's a challenge to protect trade secrets? We have rapid technology, right? The internet, digitalization, putting things in cloud storage, globalization. How about expanding the expansion of portable electronic devices? All of these result in rapid communications. And what can happen to trade secrets? Theft, improper disclosure of a trade secret, that can be very costly. Cases generally involve theft by competitors. They can involve theft by competitors, and there's cases that involve departing employees, right, that are accused of stealing confidential information from their employers. Which of the two do you think happens the most? The theft by competitors or theft by departing employees? It's the employees, and losses have totaled annually about $45 billion a year in U.S. businesses on trade secret theft. So, what happens? What happens when a trade secret is disclosed? Once it's disclosed, its owner loses all protection. They lose all their protection. No matter how much they invested in creating that trade secret, once it's disclosed, it's no longer a secret, and it's lost. It goes off into that public domain. So it's very important. And how do we know when something's a trade secret? That's one of the things we're going to talk about. How does something become a trade secret? Well, let's talk a little bit about trade secrets, where they come from. It's been around a very long time. The Roman Empire allowed punishment of a slave who disclosed his master's trade secrets. During the European Renaissance, all of the countries protected their artisan and craft guilds from those who sought to use or appropriate their secret techniques. So it's certainly been around. By the time of the Industrial Revolution, there was some various laws that were enacted to protect industrial secrets and technical know-how, prohibiting the export of technology and prevent workers who might take them with them. Some laws around that. In 1873 is when the U.S. state courts began recognizing a cause of action, enforcing trade secret rights. The first state was Vickery versus Welch in the state of Massachusetts. The suit was disclosure. So the suit was to involve or to prevent, to stop, equity law, to stop the unauthorized disclosure of a trade secret to the method of making chocolate. And that was the first case here in the U.S. And just as we discussed with our sources of laws, this is common law. Trade secret is developed through common law using court decisions over time following, what's the magic word? Precedent. So trade secrets are governed by the individual states. So what does that mean? Do you see problems? Yeah, if, states can make their own laws. So the laws and trade secrets differ from state to state. And that is going to stir some problems for businesses that operate in more than one state. This is in 1979, the National Conference of Commissioners developed a Uniform Trade Secrets Act and recommended that states follow it. Why? Why do you think they created something like this? To keep the laws consistent, right? And keep it consistent. Bring uniformity so businesses can operate from state to state. And 47 of our states, including D.C., Puerto Rico, and the Virgin Islands, have adopted it. And there's 3 states that have not: North Carolina, Massachusetts, and New York, the state of New York. So they have their own laws. They may be similar in nature, but they certainly don't follow this. But for the most part, the trade secret law is more predictable because of this act. Rationale for trade secret protection. What purpose? What purpose does it serve? A few purposes. One, it gives the owners the ability to sue those who have disclosed the trade secret or used it without permission. What could they ask for in this event? Well, it depends. If you have a disgruntled employee who's leaving with trade secrets, what would you do? You'd run to court and ask for what? I think equity law. Some sort of order, directive from the court saying, do not disclose. You cannot disclose. Stop disclosing if it's already kind of out there, but not out there. It's like I'm telling somebody, if a disgruntled employee discloses your trade secret and shares it with another, there's kind of been some rumors in this area. If you're from the area, the Plattsburgh area, with the Michigan sauce recipes, I'm not from here, but I've lived here long enough to know. I've heard these rumors about who worked for who and who brought the recipe where. As you can see, it does cause a stir a little bit in local communities with regards to disclosure. I kind of digressed there, but you could stop your disgruntled employee. But not only that, then if they brought it to a new employer, you could stop the new employer from disclosing it as well. So, or if they were really damaged, they can ask for some money to pay back for their harm. What other purposes? Protects the owners against free riding. They create all this great product. The algorithm for Google is a trade secret. If there was no trade secret protection, a whole bunch of other search engines, browsers, whatever, would pick up on the same algorithm, despite all the work Google put in. Promotes innovation. Right to exclude others from using. So, you could give up your license and you can give up your trade secret and license it out. They do that in franchising, right? They keep things consistent. Provides an alternative form of protection that might not be available under our patent or our copyright law, which could also complement, but let's talk about that more specifically. Oops, I switched my thing. Actually, I'm good. So we're going to focus on deterring unfair competition. No, that's not where I want to go with this. I think I have one more slide in here. I apologize. Oh yeah, no, we're good. I want to kind of talk about this copyright and this patent where they come together here. The trade secret law, like I said, provides an alternative form of legal protection for inventions and assets that don't qualify for the actual. Actually, I'm a little ahead of myself here where I want to go. I'm going to swing back around to the patent and the copyright. You need to know one other thing in between, and that's the key to this trade secret protection. And the point is, we want fair business dealings, people operating in good faith. And the case that this really turns on is the Supreme Court case, where the principal policies that underline trade secret law is the maintenance of the standards of commercial ethics. This is important to understand, and here's my point that I'm coming around to, because I didn't give you the case before. The important difference between trade secrets and other intellectual properties is that trade secret law doesn't impose liability for the mere unauthorized use or the disclosure of information. Okay? If you use a patent, if you use a copyright that ultimately is determined it was somebody else or your use was wrong, the actual unauthorized use is what you're doing. There doesn't have to be any ill will. I intended to do that. I wrongfully did it. I unethically did that. With trade secret, that has to be the key. The defendant must have acted wrongfully or unethically, such as using it by theft, by fraud, or breaching some confidentiality of duty between, that happens with an employee and employer kind of relationship. So it has to be some kind of wrongdoing. All right, let's put this trade secret, and then I'm still going to circle back around to copyrights here in a moment. So we're protecting our trade secrets. There are some requirements. You just don't get it willy-nilly. You have to have information, right? These are the three things you need. Definition of a trade secret. You need a trade secret that is its information, including, could be a formula, a pattern, some sort of compilation, a program, a device, a method. We've heard that word before. A technique or a process. We've heard that already before. And that whether it is economically valuable because it is unknown or not easily discoverable by competitors, and whether the owner of the secret info has taken the reasonable steps to keep it secret. Okay? So we need this specific kind of information that is business information. It has to be economically valuable, not easily known, and that the owner took steps to keep it secret. Here's our, I like flow charts. Here's our little flow chart. You want to ask yourself these questions. Is it information? Is it business information? Does the info have actual or potential value from not being known or easily discoverable? Is the info subject to reasonable secrecy or reasonable efforts to maintain secrecy? If all of those three things exist, we have a trade secret. And Coca-Cola takes extreme measures to ensure that their Coca-Cola recipe remains safe. I believe I've heard, or maybe I've read in prepping for this class, and another time was that KFC, there's only 2 people in the business that actually know what the KFC recipe is. Otherwise, it's locked in a safe. There is no official system for registering or publishing a publication. Like, you don't have to go to a trademark office, or like a trade secret office like you do a patent. What it is a court has to carefully review and determine on the facts of each circumstance of a case of whether or not those three things existed when somebody's complaining that their business information was stolen and claiming that it was protected. So let's break those 3 things down. Information protected. Any kind of information that has commercial value to a business or a firm, What kinds of things do we have? This is generally what courts have found can constitute, and I'm not saying this is the exhaustive list, I'm just saying this is what courts have found. Technical and financial data, recipes, chemical formulas, patterns, compilations of data, computer programs, devices, flowcharts and blueprints, designs and product specifications, methods and systems, techniques, plans, processes, research results, and customer lists and supplies. So those are the types of things that can constitute business information. What doesn't constitute this information? There's no requirement that our trade secret be fixed in some tangible physical form in order to be a trade secret. That is something that goes with the copyright. It does not go with a trade secret. There's also no requirement that a trade secret be in continuous use. Like the business has to use it continuously, and if they stop, it's stopped for a year or two, it's no longer a trade secret. A trade secret could be a one-time occurrence, such as information that's used to launch a new product and then never used again, but it's still a trade secret. That's unlike a trademark that has to be continuously used. Alternatively, trade secret may have potential value and not be in use, such as information regarding the future expansion into a new market. Information need not be unique or novel to be protected. You need this for a patent. You also need novel for a copyright too. The information does not need to meet some level of originality or creativity, distinction from copyright. Because novelty isn't a requirement, it is possible that more than one business can actually own a trade secret in the same information. They might not know, obviously, about it because it's a trade secret in their business, but they could. Also, a trade secret can be a unique combination or compilation of known or publicly available elements, like a recipe, right? We all can get our hands on different ingredients, but the recipe in a particular order, done a certain way, with certain specific things, can constitute a trade secret. A computer program consists of publicly available mathematical formulas and algorithms, right? So where's the trade secret? In those things, the trade secret exists in the arrangement or the integration of the elements. Some other protected information not found on that list, but certainly can be recognized. Know-how information. What do you think that might be? The know-how. Information and expertise gained through use, experimentation, or experience with a product. Might be market methods, pricing strategies of a particular product. Negative information as well is protected. It doesn't have to be positive. What do I mean by negative information? It might be knowledge resulting from lengthy and expensive research and development efforts that a certain product or strategy or method doesn't work. That's good to know. Your competitor would want to know that, right? Then they don't want to do it. So, why? Actually, I just said my question was to me. Why would that be protected? And I just told you. Next up, what's not protected information? General experience. We have the know-how information, but general experience. And what do I mean by general experience? Aptitude and skills and abilities that an employee acquires in the course of his employment. Okay? That information is obvious and widely known by the public and within a specific industry. Of course, there are people who, based on their job, have access to more information and trade secret information. That's not general experience. Okay? Skills that you obtain through the normal course of your employment is not protected. So if you have a job working as a manager at Coca-Cola and you leave to go work at Pepsi, while your experience will probably be really great for Pepsi, it's not a trade secret. That next element after information is the economic value. Does the info have actual or potential value from not being known or easily discoverable by competitors? So our rule is the information must be sufficiently secret that the owner acquires some actual or potential commercial value or advantage. The recipe to KFC, right? That's their product. That's how their food taste is based on the chicken's recipe. The value or advantage of the info must arise because it is not generally known and can easily be replicated. And that's the case. That's the case in all of those examples that I gave you. I don't want to expand on too many because I want you guys to look for some as part of an assignment. But WD-40, I have no idea how that stuff works, but boy, it fixes everything. I would love to know what's in it, right? It is the secrecy of that information that makes it valuable because it gives the business an edge over those who don't know about it. I'd love to make my own WD-40. The test for secrecy is not that information is unknown to the public at large. The test is that the info is unknown to those in the industry who can obtain economic value from its disclosure or use. So if the information becomes available to competitors who could exploit it, then it is not protected. The amount of time and effort used to acquire the info, the competitors acquiring the info, is irrelevant if the information is already available. So what makes information known or readily available? If it's online, it's in public libraries, it's been published, it's in journals, it's in public records. But on the other hand, if information is not readily ascertainable, when a substantial investment of time, expense, or effort would be necessary to acquire or duplicate it by proper means, then it becomes less easy and it's more difficult in getting that information. So that's what you're really looking for. It's information that is not commonly known, either or, like I said, easily ascertained. It takes effort and lots of testing and experimenting to get something that would constitute a lot of hard work over time developing a client list, so to speak. So why reason for secrecy? Known and easily discoverable information can't be protected as a trade secret because of the public interest. The public interest encourages competition. So that's the reason for this secrecy. If it's known, then if it's known information doesn't encourage competition, right? So having protection for information that somebody works hard to discover and create is really what this is all about. So we have our information, we have economic value in what's being claimed as trade secret information, but now we have to show that the owner must make efforts to maintain its secrecy or confidentiality. So we're going to assume that the information's economic value results from it not being known to others, is what we're doing. The owner must make these efforts to maintain that, and they have to focus on taking affirmative steps to protect its secret. So what steps? How about, is it absolute secrecy necessary? Has to be absolutely? No, because businesses, what do? They share this information with their employees who must use it, or they might have to share it with their suppliers at some point. Only relative secrecy is needed. But what do I mean by that? What do I mean by relative secrecy? Our test is that efforts that are reasonable under the circumstances to ensure that information does not become generally known to others who could profit from its disclosure. Okay, so if the trade secret becomes known, we know that it's no longer a trade secret. So what is reasonable efforts? What's reasonable efforts? It depends on what's being protected or what the information is, right? Well, there is no one set of measures that will guarantee the secrecy requirement is met. What is considered reasonable for maintaining the secrecy of a database of confidential research findings in a large corp where there's hundreds and hundreds of employees is going to be different than what the secret formula is for mixing a color of paint owned by a family-run business. Here's an example. A trade secret cookie recipe was kept in a safe, and the owners distributed only portions of the recipe to suppliers of the mixes that were later combined by employees who baked the cookies without knowing the ingredients. What do you think of that? And they use using confidentiality agreements can also help in maintaining secrecy. But that's a good example of to maintain that their cookie recipe remains safe, they have it in a safe. And their supplier who supplies, let's say it's chocolate chip cookies, the chocolate chips, that's all you need to know is I need chocolate chips. And the flour, that's all you need to know is I need the flour. And then they have employees who will do the mixing, but they don't know what the ingredients are, right? The ingredients get put in by a different employee. So they're taking steps to keep the whole recipe from being discovered. You can use confidentiality agreements. You can mark your files as confidential or secret. The key is, oops, I thought I had a slide for key. The key is the main advantage. Actually, I do have a slide for this. The main advantage of a trade secret compared to copyright and patent protection is that there is no limitation on the duration of the trade secret protection as long as that information remains secret. Okay, we already learned the patent protection's 20-year limit. We will learn copyright's duration when we get to copyright, and it's a very long time. It's a lot longer than 20 years. But it's shorter than a duration on a trade secret, which can last indefinitely. Enforcing your trade secret rights, this goes back to what you'd have to show. This isn't just you unauthorized use of my trade secret. You have to show some improper conduct. So there's liability for it. The fancy term is called misappropriation. How it occurs, how you think one becomes liable. We just talked about it. Departing employees reveals to a new employer. Or they may use their own trade secret to set up a competing business, right? They venture off and try and use their vendors and their consultants and join other partners. So one is liable for misappropriation of one's trade secret if it acquired by improper means, stealing, bribing, gaining access, like hacking a computer system, or fraud. That's the first one. Or when he or she discloses or uses the trade secret without permission. So that's, no consent to do so. And it can be done expressly or implicitly. Or they do it in breach of a contract. There's a confidentiality agreement. So if you're the owner of a trade secret and you have a disgruntled employee, or there's an employee that might leak your trade secret, that's the action that you take in court that you would have to prove. What if the owner of the trade secret revealed the trade secret by mistake or accident? Oops, is it gone forever? Actually, if the use or the disclosure of the trade secret, if it's clear from the circumstances that the owner revealed it by mistake or accident, it's still going to be a trade secret, and the owner can seek that it remains that way. But that's, if it's obvious that it was a mistake or accident, the court system, or it's not going to be leaked into the public domain because of a obvious mistake or accident. Are there any defenses to this? Can there be a defense? When is it okay to use a trade secret? Is where I'm going with this. When is it okay? Our plaintiff, who is usually the trade secret owner, has the burden of proving that the information qualifies as a trade secret. Okay? Based on those three things that we just talked about. And the information that is not generally known and that they took measures to protect it. And they have to show there's misappropriation, inappropriate means, okay? If the trade secret, though, is obtained through proper means, that's a defense. So the question is, what constitutes proper means? And you may have heard of number 2, and obviously number 1 is independent innovation. Somebody else created the same customer list. Oh well, there's only so many people. So customer lists can overlap with a competitor's list. The trade secret doesn't create exclusivity. It just gives somebody a trade secret. You can't use my list that I created. You can't use my algorithm I created. If somebody else came up with the same algorithm that Google uses through independent innovation, that's not stealing somebody's trade secret or having it disclosed by improper means. The other way is reverse engineering. Reverse engineering is the process of starting with a publicly available and lawfully obtained product and working backwards to systematically disassemble it into components and parts and elements and analyzing it to create a replica in your own. This is not this is a defense, and this is not taking somebody else's trade secret. If you took let's go back to my cookie example, and you bought the cookies and you decided that you were going to figure out what is in this cookie, you may spend lots of time trying to recreate it. Or WD-40, trying to figure out what is in it. You can, reverse engineer. Reverse engineer works a lot with patents too, and that's one of the bases of that movie that I told you about when I talked about patent law was The Flash of Genius. That's one of the arguments that Ford had made in that case. So there are some defenses: independent innovation, and if you've reverse engineered the trade secret. Remedies: you can ask for money. Remember back to our American legal system. Common law damages. If you're trying to stop somebody from using your trade secret, you're going to seek equity law, injunction. Okay? All right. That was a little bit longer on trade secrets than I wanted to, but that's the snapshot and overview of the intellectual property of trade secrets. Next up is trademarks.